Mahalo Kauai for taking this very important first step. I was born and raised on the big island, island of Hawaii. And I am currently a resident of Pa'awilo. And I am humbled to be following these articulate people like Alan Murakami and Tom Pierce and Richard Stevens. I'm not as good a public speaker as any of them, but I'll try my best. Okay, first off, I would like to start with sharing with you some of my favorite pictures of some of the most beautiful ancient Hawaiian trails. And some of these pictures you have seen already because, you know, Richard and Tom used them before. I had the poor judgment of choosing this topic for myself. How can we hold the state and county accountable for the protection of ancient Hawaiian trails? This is a very difficult topic, but I'll do my best. A bit about myself. Most of my experience has been with ancient Hawaiian trails on the island of Hawaii. And here we have a foot trail, what we call the Alaloa, and it happens to be located on state-owned lands. So I believe that we can feel more secure about the future of this trail. This is in Kipahoehoe, also in South Kona District, also a foot trail. And we say a foot trail because many of these ancient trails became used when horses became commonly the mode of transportation. But the horses' hooves would slide on the ala, the smooth, ocean-worn stones. So this is strictly a foot trail. And you've seen this before in somebody else's slides. And this is an old cart road in Honaunau to Kealia, South Kona District. And it's just physically beautiful. This is an Alanui Aupuni, or government road. And in the archives are the records that show just how much government expenditure went into the building of this trail. It was built in the mid-1800s in South Kona District. Very impressive, and was used when horses were more widespread as the mode of transport, and it became a more direct route, although there are ancient Hawaiian foot trails further towards the coast in this area. I was born, as I mentioned, I was born and raised on the island of Hawaii in a family that was very active in hunting and fishing. And we didn't do the hunting and fishing for recreational reasons, although we certainly enjoyed doing it. But that wasn't the main purpose. It was to help supplement the family food budget. It was necessary. So when I grew up and saw the way our islands were changing, I became concerned that I could easily see Hawaii become a place where only if you had the money, only if you had owned the land in the right place, would you be able to have access to the mountains and the ocean. And I felt that that was wrong. And it is a matter of social justice for me to be working on public access and the protection of ancient Hawaiian trails. And I've been doing that for going on 34 years. I lobbied for the establishment of the Hele statewide trail and access system and served as the first coordinator and planner of that program. I also lobbied for the Alakahakai National Historic Trail, which incorporates all of the historic trails I've shown so far. And that became approved by Congress in 2000. I've worked as a planner for the Hawaii County Planning Department for 5 years, and for the past 8 years, I've been self-employed as a planner focusing on public access and trails, in addition to being a beekeeper. I'm also a commissioner of the Hawaii County Cultural Resources Commission. While I'll try to focus on ancient Hawaiian trail protection today, as other speakers have alluded to, there is quite a complex bundle of issues when we talk about trails and access, and public access is its own set of challenges. And so this slide is intended to give you an idea of what inevitably comes up in the discussion when we talk about trails and access. So we have ancient Hawaiian protection. Now, is this for public access, or is this better kept protected for Native Hawaiian traditional and customary access? The two do not automatically go together. Historic preservation. Commonly, ancient Hawaiian trails go through very delicate areas, and we have to be concerned about the possibility of burial sites in the area, historic sites that have not been secured and protected and could be looted by artifact dealers. So I cannot stress enough that historic preservation and cultural concerns are very important when we talk about ancient Hawaiian trails. We talk about access rights, and yes, the laws of Hawaii today do give the public rights to shoreline access, as well as the mountains, although you have to, it's not, that gets very complex too, but I want to also make sure to say that public access is not just a matter of your rights, it's also your responsibilities. And if you do not conduct yourself responsibly, it becomes a backlash. It gives public access a bad name for all of us. Management and maintenance, that's always a very, very big challenge and comes up immediately. It's like, okay, you want to open this up, how are you going to manage and maintain it? Management and maintenance relates to liability, historic and cultural preservation, use and overuse of very sensitive areas, the inability to prevent guidebooks from revealing the trail's location. Also, community access. How can we do that? On the island of Hawaii, the conversation in communities has been increasingly talking about how can the community become more responsible and involved in the management of their accesses in their own backyards, because there's a feeling that when we rely on government to do it for us, it's not done right. But community access requires resources, and how are we going to be able to do that? Land banking. I am a strong believer in land banking because many times the opportunities come up to secure a public access or acknowledge ownership of an ancient Hawaiian trail, but then you hear this sad story that all of us keep hearing that, oh, we don't have the staff, we don't have the money, we can't do it. Well, let's land bank it, let's put it on the side, but let's not use the lack of resources as the reason for not doing anything. And that we, the people, have to make that compelling argument. What it says up there is techniques for holding the state and county accountable for ancient Hawaiian protection. What I tried to do was to list some of the more important techniques that I've tried for the last 34 years with not always 100% success. Partial successes, sometimes temporary successes, and as has been mentioned by other speakers, you have to be vigilant. You cannot say, oh wow, we won, and then walk away from it. Knowledge is power. Know your facts. Be prepared for the long haul. Resolution of your concerns may take a long time, and a lot of you know that. It takes years. Follow up on unanswered letters, requests, and phone calls. This is a big one. Commonly, you don't get a response from government when you send in a letter. The paper trail is important. Don't rely on email, because email is often treated as an unofficial correspondence. The system is complaint-driven. It helps to use pictures and also video. If you're going to participate in a shoreline certification determination, it's been recommended to me that the most effective is when you go there during the highest wash of the waves, etc., with your video camera, and you can actually photograph how high up the coast this water is coming. That is the most effective way. It helps to work with others. Do not burden one or two people with all the work. Burnout happens to all of us. Know who your friends are in government. This other speakers have mentioned before. Relationships are very important in Hawaii, and you can burn your bridges. And there are ways that your concern can continue to end up in the bottom of the pile. Learn which agencies have jurisdiction over what, where public information is kept, and how to locate and view agency files. Be proactive by getting on the email notification lists for Board of Land and Natural Resources meetings, Office of Environmental Quality Control environmental notices, where it is announced when people are going to apply for shoreline certifications. There are also, at least for the island of Hawaii, subdivision application notices that can be emailed to you. Those are important to monitor. Also, when you know that studies are being done that involve archaeological reports, those are a wealth of information as far as whether the archaeologist has even acknowledged that there's a trail in that area. Learn to read tax map key maps and find them on the web. Very important. Hele is the only program in the state with the legal mandate to plan, develop, acquire land or rights or public use of land, construct, restore, and engage in coordination activities to implement the statewide trail and access system. It would be good to study that law. It's also important to watch this program and also help it if you can. When you read that law and see how much is expected of this little program, I think it opens your eyes to why sometimes you are most unhappy with what's not being done. Claiming an ancient Hawaiian trail as a public trail is a complex process and does not assure that the trail will be opened to public use. Learn what the concerns and barriers are. Are they legitimate? How can they be addressed, if at all? I used to be like that. These people in government oftentimes are unable to leave their desk. They have permits that keep coming through, which if they do not review and process, get automatically approved. So I think it was your new archaeologist who invited you to be eyes and ears for her, because chances are she's going to, she may not be like this, but she will struggle to cover everything. And if you cultivate a relationship with her to the point where she can feel that your opinions are worth listening to, and also back it up with photographs so that she can actually see what you're talking about. Over time, I believe that your communication with people in government such as this could improve greatly. Unfortunately, permits with public access requirements, and this is in the subdivision ordinances that are processed by the county of the counties. At least for our island, there are a number of these public accesses that are being approved by people who never leave their desks, and it is bad. You end up with an unusable access that for years later is a paper access. It's on the maps, it's on the tax map key maps, plainly shown, but on the ground it's not usable and cannot be located. This is where we were before the Coastal Zone Management Program got passed in 1977. This is one of my favorite cartoons, and you can see that it's dated 1975, so it was before the passage of the Coastal Zone Management Act. And it may appear to be an exaggeration, but there are seawalls, saltwater pools, boat ramps, boat moorings, and on, that are grandfathered in. As long as they can show that they were built before June 22nd, 1970, they are grandfathered in. So they can even repair them, even though they may be obstructing the public's ability to go through what is called the Beach Transit Corridor. I mentioned that it's important to know which agency is in charge of what, because it really helps prevent you from spinning your wheels. For example, if you have a water quality issue and you try to complain to the county planning department, they're only going to refer you back here. And it's not always that easy. Just not too long ago, I ended up making 10 different phone calls back and forth all around, because even though I believe I was clear on which agency does what, you often struggle to find the right person and the right office. So anyway, if you have a shoreline setback issue This is a key line right here, the shoreline. DLNR is responsible to determine the shoreline or make that determination. And anything landward of the shoreline would be county jurisdiction, and concerns that have to do with the ocean waters become state. Now, it's very important to know the shoreline definition, and it helps to be an attorney to understand it. And I've had to read this definition over and over and over, and a lot of times you see people just say high water mark. Well, that's not the same thing. So, the shoreline definition is the upper reaches of the wash of the waves other than storm or seismic waves at high tide during the season of the year in which the highest wash of the waves occurs, usually evidenced by the edge of vegetation growth or the upper limit of debris left by the wash of the waves. I have to read this over and over to remind myself. Anything that is seaward of this shoreline definition is the beach transit corridor, which we have the right to be in. So one day I'm walking along the coast, and I encounter this beach, South Kohala. Now, where is my beach transit corridor? You've got this hotel putting out beach furniture every morning, lounge chairs, packed, most of them not even being used. Is this okay? No, it's not okay. And so I did lodge a complaint and made sure to include my pictures, but what I didn't do was follow up. So I really don't know if anything happened. So what I'm saying is I'm not holding myself up as perfect. I get busy, just like everybody else, and I failed to follow up on this one. This is one of my more recent complaints. Here we have a kayak rental operation. It monopolizes the government road that leads to the historic boat. Oh, sorry. It leads to this historic boat ramp where they store all of their kayaks. They do not have an SMA permit. They do not have a conservation district use permit, but somehow they do have a commercial kayak permit. So this is something that I'm still needing to, that famous word, follow up on. But where is the beach transit corridor here? And my brother and I are saying, what if we were to bring a kayak and attempt to just exercise our public rights by going on the public road, walking our way to the ramp? Would we be able to use it? The way it looks now, we wouldn't. Oh, and I also included that picture because this is a Hawaiian family. This is not a resort that is blocking the public transit corridor. And we tend to really get huffy and pursue the resorts, but this is our own local people doing this. Hokulea has been mentioned by the attorneys that have spoken to us. And I'm so glad, Tom, that you talked about how litigation has its downside. And don't think that it's going to be your first option. It's way better to exhaust other ways, if at all possible, to get resolution. And here we have Hokulea. Now, I haven't been there since 2012 when I took this picture. But after years of litigation, a settlement agreement was finalized in 2006. So 6 years before I took this picture. And in this settlement agreement, the developer agreed to dedicate a an easement, a public easement that would essentially connect two ancient Hawaiian trails in the development so that people could seamlessly walk on these ancient trails and go along the coast. They have used their bankruptcy as their reason for not being able to do this. And as of 2012, you cannot use the trails. They've got them blocked off. If you call the Hokulea management and you ask for permission to use the trails, which we shouldn't have to do, you will be refused. Okay, now before I'm going to close with a few examples. And one example that I want to share with you is that years ago, our Hele Advisory Council meeting was packed, standing room only, by equestrians who very passionately told us how this trail we've got to protect because it's the last remaining equestrian trail in Waimea that we can use. And we really need help with this to protect it. And we never saw them again. Now, the Hele program did look into it, and we did arrive at a few impressions, but we didn't have partners in this because they didn't show up after that. Years have gone by. So I don't know if the trail is still workable. Maybe they didn't come back because they managed to keep it open. I really don't know. But that is an example of what not to do. Don't think that you can give government its marching orders by just showing up and doing a one-shot deal. It is going to require time and effort on your part. I'm not saying that's right, but that's the reality. There is a North Kohala Access Group that has been meeting once a month for years. And what they do in their agendas is they go down the list of all the different public accesses that the county has required public accesses to be dedicated in, and they check on the status of them. And they write letters to the county planning department. They expect answers. And they are, I think, a very good example. This is a group of people, and they're like bulldogs. They just don't give up, and they follow up. So there are groups that are I think, having a certain amount of success. This is a successful example that I want to share with you in which I didn't work with any group, it was just me. And the way that it came about was that I was looking at the Board of Land and Natural Resources agenda, and I saw that one of the items was that Kona Village Resort was trying to get the state to approve its use of offshore waters, because as you remember, the state has jurisdiction of ocean waters. And I had been getting pretty irritated by these signs on the Kona Village Resort property. They're not showing that well, but it says kapu, no fishing, public access. And so I used that as an opportunity. The meeting was to be in November of 2008, I think that is. And I used pictures and I posed questions. How can the resort do this? Is this okay? Is this a violation of public fishing rights? And it was just amazing, because a month later I get a letter from the then director, Laura Thielen, and this letter essentially says, and I can't see the wording very well from here. Probably you can't either. But essentially it's saying, we agree with you, this is a violation. We are going to tell the resort to remove those signs. And then a month later, Kona Village Resort sends a letter to Laura Thielen saying, we've removed the signs. So I felt good, yay! And it was relatively simple. There's more to the story, but I need to move on. This was an example where I worked with a group, and the Emau Nale Hele nonprofit organization expressed to the county planning department that we were tired of waiting for this shoreline public access Mauka Makai to get built. It had been required 15 years ago in a special management area permit. And so the county said, oh yeah, what happened to that? So they wrote a letter to the landowner's realtor, and then the new buyer of the property cleared this huge, it was way bigger than he needed to, but he cleared this huge path down. It's a short Maukamakai that gives you a beautiful view of Hilo Bay. There's a black sand beach, but not an accessible black sand beach because it's below a cliff. Anyway, this property is a historic property. It contains a very historic Hilo Consolidated Railway Tunnel, and it also had some historic remains, concrete of the old sugar mill that was there. And this is a picture of what the tunnel looked like back in 2011 when we were lobbying for this access to be cleared and built. And then once it got cleared and built, here in 2013, we find major graffiti all over, plastered on everything, all of the historic concrete pillars and walls, and in the tunnel. So I entitled this, How Bad Behavior of a Few Ruins Public Access for the Rest of Us. And so the landowner said this in signage, but indeed the landowner cannot close the access because this is a requirement in a special management area permit. So he's got to just live with this. And this final example, I'm really sorry the wording doesn't come through on the letters, but this was a David and Goliath struggle. And I think you will see some parallels between what happened in Kona with this trail issue and some of what you're experiencing. What happened was that a developer, Stanford Carr, who's a pretty heavy hitter, had an archaeological survey done ahead of him moving forward on his planned community. And this archaeological report, which illustrates how important it is to know what the archaeological reports are saying. This archaeological report said, there is a trail, Maukamakai Trail, road to the sea, and it's been so damaged, and through the years you can barely even find it, and it was converted to a jeep road back in the war days, and we think that we can just, use it for information only, but no preservation necessary. So State Historic Preservation Division writes a letter and says, we concur. And along the way, the Nale Hele Advisory Council asks the program to abstract this trail just to see because the Hawaiians of the area are telling us, this is a historic trail, our ohana used it, it's a major trail that used to be used to get down to the ocean. And so a abstract was done by Moana Roland, and it was shown actually that there were 2 Maukamakai ancient trails, and that the state felt that it fell under the Highways Act of 1892 as owned in fee. And I know that's supposed to be an outdated term. I don't know why, but anyway. This letter, which you can't read very well, is from Peter Young, who was then director of DLNR. And Peter Young is saying, well, as you know, there's been considerable community concern raised about the future of this trail. And we also feel that the state has reason to claim it, and that the ownership issue is in question. And we would appreciate if you would work with us on this. Well, ownership of land in Hawaii is key, and that grabs developers' attentions. And so as we were looking at the archaeological report and hearing from the lineal descendants of the area, we felt as a council that we needed to go out there and look. So we went in there and we took a look, and lo and behold, we found a section of trail with the old curbing on either side, and there was a papamu right next to the trail. Papamu would be a stone with the konane board game on it. So that really encouraged us. Oh, no. And it encouraged us. It was really quite a confirmation that we were right, that we really should be continuing to fight this. And fortunately, we did have a lot of Hawaiians that were in full-hearted support. And Hawaiians who actually remember their grandparents living in this very area. And so they came forward and they said, we're going to form an ohana group. And this is not only ohana who were, identified as being kuleana owners of this Ahupua'a area, but even our own other extended ohanas. And so it became a pretty big group. And it was hard for, I think, the state or the landowner to ignore the compelling arguments that were being made. And there was something else. It'll come to me. So what ended up happening was that Stanford Carr's representative met with the ohana group, and they hammered out some very specific details on what would be acceptable treatment of this trail. And what I was forgetting to mention is that the developer was asking the state to quit claim its rights to the ownership of this trail. And everyone, Hele, the Hele Advisory Council and the ohana group opposed this and said, no, this is too important. And it is irrelevant that there are portions of the trail that are in poor physical condition, because it is still a culturally significant property that we want to see preserved in place. Initially, the proposal was, okay, we'll preserve it, but we'll move it to the sidewalks of our planned development. And I was like, are you kidding me? That's so outrageous. But in the face of very clear objections, this letter shows a list of very specific consensus agreements that came about that said this trail is to remain in place and that it will be 10 feet wide with 10 feet wide buffers on both sides. And the buffers will contain only natural vegetation that is native to the area. And we will allow no more than 4 breaches of this trail because keep in mind, you know, they've got their subdivision with roads that they have to go through. And as much as we didn't like the idea, it's more you have to be realistic because this development had all of its zoning and it was really at the point of getting their subdivisions approved. And we were holding up the subdivision approval until the trail got secured and clear as to what was going to happen. The other thing that the Ohana did, which was really, I thought, creative, and that was any rocks that had to be removed, say in the breaching of the trail or any kind of, you know, earthwork, the rocks needed to remain on the property and be reused for that property. And any trees, whether dead or trees that have to be cut, those would also be utilized by the Ohana and possibly you know, given out to people that the Ohana knew who were woodworkers. So I thought this was a success. And so I'd like to close by reminding us all as to why we're here today. We're here obviously because of the ancient Hawaiian trails, and we are sharing in our love for them and our belief that they need help. And there are legal ways for the state to dispose of them. So we really do need to remain maka'ala, or vigilant. And I think that the more we can work, ideally, with people within government, we should try to do that. Because there are people that want to work with us. They want the help, who are in government. But we need to know who our friends are. And I want to thank all of you again for having this workshop, because through the years, I've thought, oh, wouldn't it be great to have a workshop? But you know, I'm only one person and never got it together. But I thank you folks in Kauai because I know it's a lot of work to do this. Mahalo.
Thank you so much.